evening, Epic Understanding family. I am Coach Love here with another fantastic episode. But what I'm really excited about is who I'm able to bring you tonight. I am able to bring you Max Elliott. She is a fabulous attorney that has a heart for the people who she helps. Now, she is going to help educate us on how to use the law so that we can have a fabulous legacy. We don't work all these years only to have our wealth go to taxes. So she's going to really help us out. So let us give a warm welcome to Miss Max Elliott. Hi,
Oh,
welcome.
hi, Erica. Thank you so much for inviting me and having me on as your guest. It's quite an honor to share what I can and just to actually chat with folks about wealth and loved ones and caring for everything that really matters to us.
Exactly. So I'm curious, how did you decide to choose this type of law? As a matter of fact, why don't you tell us about yourself a little bit? How did you choose the law?
Well, the law chose me
Mm,
because I had not intended actually on going into the law. But I always loved helping people. And
mhm,
as I was trying to figure out what my next career was going to be after publishing a book, I worked for the American Bar Association actually in their international liaison office at the time, which was the legal handshake, if you will, of United States lawyers to international lawyers and international legal dignitaries. And across my desk came a lot of information about human rights attorneys and attorneys who are just doing amazing work. And I had always that was not the opinion of attorneys, in the neighborhood
okay.
and where I grew up. So I started getting this information, and I said, okay, I think that might actually be where I need to rest my hat, my career, and so I decided to apply. And my initial desire was to actually be a international human rights advocate, but I went
Okay.
into the law as kind of a non-traditional like senior student, and already had family with NATO, and so we decided that me staying at home would probably be a little bit better. And so I was like, so how do I reconcile what I wanted to do internationally with maybe a fee-based practice? And so I always had a very strong affinity for helping women, children, families,
Mhm.
and property. So I was like, okay, wills, trust, and estate planning seems like a perfect fit. Probate seems like a perfect fit for me. And then it also allows me to do pro bono work on the side. So that's how I.
Okay. Now you used a word that many people are familiar with, and that is probate. Okay. Now that's the place that everybody wants to stay out of, right?
Mm-hmm, mm-hmm.
We 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 want to stay out of probate court. So let's talk about the easiest way to stay out of probate court. How is that? What do we need to do?
Okay, so I think we're going to really just let me kind of drill down on a few points, because that could, that could take us into midnight if I actually talked about the whole
Okay.
plethora of mechanisms that would allow us to stay out of probate. So probate is an issue about death, and so let's not go there right now. Let's talk about life. And but in Illinois, probate also covers. There's also the guardianship bench, and the same
Oh,
thing
okay. Yes.
in New York. So let's conservatorship. So let's kind of talk about. How to stay away from that particular court, right? And so you do that using what we call powers of attorney, and what I refer to and what our
Okay.
firm refers to as advance directives. So
Ah,
yeah, yes, exactly. So what happens when someone becomes disabled or is a minor child? And let's say the minor child may have a parent who passed away, or even a grandparent who left them with significant wealth, more than what could be gifted using a particular law called the Uniform Transfer to Minors Act.
okay.
If a minor inherits wealth like that, then then somebody has to apply to be a guardian of the estate for that child. And that even occurs if the child has parents. It does not matter, because those assets belong to the child. So that's kind of an easy, that's kind of the easy road. The challenges that I continually face, and I think we're facing more and more of now as baby boomers age, as our parents and grandparents become more dependent on us and unfortunately lose some of their mental acuity. What then happens is, if they become disabled and they do not have powers of attorney in place, then our loved ones, and consequently us, will find ourselves in guardianship court. And so,
So that is amazing that you bring that up. Can you help us understand a little bit about what guardianship court is? What is that?
mhm. So again, if somebody does not have the mental acuity, if they lack capacity in either a limited mental capacity in either a limited or total way, then
Mm-hmm.
and they do not have powers of attorney, then someone can petition the court to actually act on that person's behalf. And a lot has to happen in order guardianship to be for a guardian to be appointed. Because if you think about it, you're actually taking the rights away from an
Mm-hmm.
adult to handle their own affairs, handle their bank accounts, to handle their bills and things like that. So if, for example, someone has limited capacity, means that, let's say, for example, someone has dementia, grandma has dementia, and she goes in and out a little bit, right?
Right.
Sometimes she's there and sometimes she's not. Well, that's limited. And if she has limited, she may every once in a while get a little feisty and know what she wants.
Okay.
And then you actually have to tell her that she's going to be subject to a guardianship proceeding,
Okay.
and have her understand, if possible, what that means. And if she does understand what that means, then there may be some issues there. She may not want to participate. And so
Mm.
but it's a due process issue. So we have to notify her, we have to try and tell her what's going on, and we have to try and get her to court. And even if you want, but first you got to back up a second. Before we do that, we actually have to have somebody, a medical professional, to
Okay.
actually state and provide on the record for the court whether she has limited or total incapacity. So you have to
So
get, I'm sorry, go ahead.
so this is actually in pop culture right now. Britney Spears. has a conservatorship. So, what is the difference between a conservatorship and a guardianship? What's the
Right.
difference with
So,
that?
yeah, so they can be in certain jurisdictions the same thing. But a conservatorship, if it's not the exact same thing as a guardianship, it really is basically what we call a guardian of the estate,
Okay.
a
Okay.
protectorate of money, of assets, someone who holds the purse strings and will have the ability to deny the the subject of the conservatorship
Mm-hmm.
uh, their deny them whatever they want. If I want $100, the conservator can say no unless you give me a compelling reason
Oh, wow.
why you want $100, unless it's actually written in the court order that this person can have $100, $200 of mad money a month,
Okay.
right? And so then the conservator would have to do that. But past that, the conservator or the guardianship of the estate does not have to fulfill that person's request.
So they can say no, you can't have money.
Mhm. Yeah, it depends on what's in the court order.
Okay.
Mhm.
Okay. And so, I hate to bring up Britney Spears again, but it's so relevant. The fact that she was saying that she was being made to um, take birth control.
Hmm. Right. And so again, that's a really, really thorny and troubling topic because there are a lot of laws that touches on, right? First of all, it touches on the right to bodily integrity.
Okay.
There's case law out there where the United States Supreme Court stated that one cannot make another party uh, take something or do something or participate in a medical procedure that they don't want to.
Hmm.
But the caveat and the exception to that, and there are always exceptions to legal rules.
Hmm.
The exception to that is if not doing so will cause themselves or someone else harm. And so, uh, you know, I don't, I, I don't know the complete backstory. I haven't read the order or anything like that, but I would surmise that um, she's being made to take birth control because the court has deemed that it's in her best interest not to give birth. And of course, now that brings up that whole reproductive rights issue, which I don't
Right.
think we want to go down that go
No,
down that,
no, I definitely don't
but
want to
that
go
does bring
down
it
there.
up.
But just listening to you, what you're saying is there is an avenue to defend that particular action if someone has a conservatorship over you? Or
Mhm.
is it because they have the guardianship? Which one controls that? Or is it both?
Right, exactly. So
So,
a guardian of the person will will actually sorry will a guardian of the person will have that kind of control,
wow.
and a guardian of the person linked with a conservatorship
Mm-hmm.
will have complete control.
Mm,
A guardian of the person has the ability to make decisions regarding your health care,
mm-hmm.
regarding your education,
Mm-hmm.
regarding anything else that is in the court order, but generally healthcare and education. So birth control, of course, falls under healthcare.
Okay.
So the guardian of the person can explain to the court that it is in this person's best interest to take birth control.
So if we wanted to, because really, I'm just thinking about this, guardianships and conservatorships are typically very expensive. And the person who is actually ending up being controlled is the person that normally pays for it.
Their estate.
So their estate with the money that they've earned. And then not only that, but they pay for a person from the court to watch the person who's watching them.
Correct. It's
Oh my
called
goodness.
it's called guardian ad litem.
Okay.
And so the guardian ad litem is exactly as you articulated, the court's eyes and ears, the legal court, the court's legal eyes and ears, because typically this person is a lawyer.
Okay.
And the guardian ad litem's report assessment is generally weighed has much heavier weight
Okay.
than the person who is under guardianship or even their attorneys.
Mm. Mm. And I have to say, honestly, that sounds scary to me. I didn't go through the whole process, but I experienced some of that with my aunt. I think I shared a little bit of that with you. And that is why I think it's so important that we really do it on the front end and pay attention to powers of attorney. So, can we kind of talk about those and the different levels of those?
Sure.
Awesome.
So powers of attorney, we talked about a little bit earlier, I touched on, are also known as advance directives because
Okay.
they are done in advance, right?
Yes.
So they're done before they're needed, hopefully. And most states have 3 types.
Okay.
So you have a durable power of attorney, which is almost obsolete. Best practices for estate planning attorneys is not to use that because it tries to lump everything into one instrument. And
Wow.
it can become, things can slip through the cracks. So best practices are for folks to use a power of attorney for financial affairs, or known as a property power of attorney, and then a power of attorney for healthcare.
Okay.
And so the property power of attorney, like I said, covers all financial affairs, not just real estate. And it allows you to designate someone and a successor to them if you want,
Okay.
to make decisions on your behalf when you are incapacitated.
Okay.
Good powers of attorney actually define what incapacity is.
Okay.
Because there's a legal definition and then there's a medical definition.
I see.
And depending on where you land, right, where the person lands, if the legal definition is not sufficient for the doctor, then there might be a problem, right? So you want to make sure that those definitions are, the definition of incapacity encompasses both the legal definition and a medical definition. You might also want it to encompass what we call a constructive definition, which is neither legal nor medical, but just makes common sense. It's like, if I can't answer questions intelligently, then somebody needs to help and make decisions for me. So that's kind of like the constructive definition. And so that applies to both, like I said, property powers of attorney and powers of attorney for healthcare. Both advance directives can be designed as narrowly, can be tailored as narrowly or as broadly as one is comfortable with. And what I mean by that is the authority that you give the agent, which is the person who you would designate to act on your behalf if you were to become incapacitated. Now, folks tend to designate loved ones, tend to designate children, grandchildren, spouses, and for financial matters, yeah, it might work out.
Okay.
But I always tell folks to think about the acumen, especially with respect to finances. If you're incapacitated, let's say you have a long recovery period, and unfortunately, let's say you had a TBI, a traumatic brain injury, and you're going to a stroke or something like that, and you're going to recover, you're on the road to recovery, but you need somebody to carry out these decisions for you. You want somebody with some financial responsibility and acumen, and also somebody who is trustworthy, right? You don't want somebody, you don't want to look at your bank account once you completely recovered and see that it went from $100,000 to $2,000. You don't want that. You want
Absolutely.
somebody who's going to actually pay for the insurance on your home. You
Mm-hmm.
want somebody who is actually going to understand the kind of care that you need and the care that you want, and not necessarily what they think you need, right? They're going to fulfill the decisions that you have articulated and spelled out in that POA. You're not going to look and see that their name somehow got on the deed to your home, right? So
Exactly.
that's what I mean by narrow or broad. If you can't, if you think that this person needs to grow into it, and you just need somebody to, you're thinking, well, I just want somebody to be able to make these decisions for me just in case, then you can narrowly tailor that. But if you think that, I'm senior, and sometimes I just don't feel like dealing with this anymore, then you definitely need somebody who's very trustworthy and who will do what you want them to do in terms of your finances. So those are
So
my
how does that help us pass our money forward to the next generation? Because I definitely get there could be a huge concern with trust, but for this moment, let's pretend that we trust the people in our lives. How does having a power of attorney help pass forward generational wealth?
right. Okay, so that's a good question, and that helps me to bust a myth.
Ah, okay.
Okay. There is a myth that uh, I don't know, for some reason, folks think that they can put their hands in the cookie jar after somebody dies. And
Okay.
powers of attorney are only effective until someone dies. So the minute
Oh,
somebody
good. That's good
dies,
to
that
know.
power of attorney ends. So
Mm-hmm.
there is no ability at that point
Mm,
to transfer wealth.
okay.
There is just none. The the issue of wealth transfer under a power of attorney does come into play if, for example, grandma is unfortunately going to be passing away within 6 months, like somebody has a 6 month to live diagnosis, God forbid.
Mm-hmm.
The agent under a power of attorney for property, depending on how it's designed, could have the authority to change beneficiary designations,
Okay.
to create a last will and testament, to
Mm.
create a revocable living trust, as long as that as long as that person, the principal, the person who they're making decisions for, has already articulated what their intentions are.
So, family, if she really just said something, Max said something very important, and I had to pull out my notebook on this point. So, um, they can create a living trust on that
It's
person's behalf.
right. So it depends on the power of attorney.
Okay.
Um, People go to the state websites or go to Office Depot or go to Amazon and they pull down powers of attorney
Okay.
and they sign them and they notarize them and they think they're good to go.
Okay.
And they're not, because you have to be able to actually understand the authority that is inside that instrument that you're signing and notarizing and having witnessed. Most statutory powers of attorney, at least for Illinois and at least for New York,
Okay.
do not allow you to create a last will and testament or a revocable living trust unless you actually expressly do so in the POA. And New York has a statutory gift rider that must be used, although I think the law changed. So, but you can't just use a regular old POA that you pull off of, like I said, the shelf, fill it out, or one of these do it yourself online platforms, fill it out and say, I'm ready, okay, this is good. I can now go create a will or a trust for grandma. No, grandma actually has to have her POA state that you have the authority to do that. It's not in the statutes.
Awesome. Well, but you said some terms that I want to tease out. We're doing a series on making, using the law to leave your legacy. So there's some words that you threw out. We're not going to do it this time. We'll do it next time. But it was, living trust, last will and testament. And I know what a will is, and I think the audience does, but I want to really break it down. And then you said gift writer, and you said something right before gift writer that I didn't quite catch. Do you remember what it was?
Statutory gift writer. Yeah. So that's
Okay.
a statutory gift writer. Whenever you hear anybody say something is statutory, that just means it's driven by state law. And
Okay.
yeah, I agree. Each one of the, dear goodness, each one of those terms could take like an hour to actually tease out. So if you don't mind, I really kind of want to go back to the healthcare powers of attorney and
Okay.
kind of
Sounds good.
talk
Sounds good.
about that
Mm-hmm.
because we're just emerging from the COVID fog, right?
Mm-hmm. Yes.
And that's shown a serious light on the need for comprehensive powers of attorney for
Mm-hmm.
healthcare. I think you and I talked about it, how unfortunately loved ones were hospitalized and could not, folks couldn't visit them. They couldn't have
Mm-hmm.
visitors. And so they were using, doctors were using their cell phones or maybe iPads. And this was an emergency. This was an emergency unlike no other we've ever seen in our generation. And so
Mm-hmm.
we accept that and we allow for that exception. But what we were allowing an exception for was actually a criminal act,
Wait,
because it is a criminal act to put your hands on someone else's device and use it without their express consent. And if
you're telling
someone was
me.
incapacitated, they can't give express consent for you to do that.
Oh,
And so
wow.
it's really, really important to have these, these new kinds of rules and provisions that encapsulate technology and the use of technology and the consent for others to use our devices, and just provisions that kind of are about the 21st century, right? And have those provisions in those healthcare powers of attorney. There are provisions that one can allow to determine. You can tell who can visit you.
Okay.
Let's talk about, sometimes everybody is not loving. Sometimes people are loving, but they don't understand what you need, and they cause more harm than good while you are trying to heal in the hospital. And
Okay.
so your advance directives are an opportunity for you to say, you know what, I love my cousin, but
Mm.
do not let that person visit me in the hospital. Let me get over it first, and
Oh,
then
wow.
I'll visit them when I'm at home. That's a really nice, that's kind of a really nice scenario. I've had, unfortunately, other scenarios where people were just, they were estranged, right?
Mm.
And if you're estranged from a family member, then unfortunately, that's the last person you want to see while you're trying to heal while in the hospital, right? And so these advanced directives, your healthcare powers of attorney, if prepared right, will actually help you heal. You know, it's just critical for those provisions to be in there.
Mm. And so now we're not really using a durable. I feel like I need to go redo my power of attorney, because I do have a health directive. Um, I don't know if I have a property one. I'm pretty sure I have a durable power of attorney, and I have a health directive. Um, are the two that I have. So I'm just thinking I got to
Yeah,
go
so
read my
so
stuff.
your durable powers of attorney cover healthcare,
Mm-hmm.
and they also cover finances, and they allow you or someone to act on your behalf when you become incapacitated.
Mm-hmm.
The issue is, if you're healthy, a healthy 35, 40, even 50-year-old, do
Mm-hmm.
you want to give somebody that kind of authority right then and there? And so that's why the instruments have been bifurcated. They've been separated, for lack of
Okay.
for in other words. So you have one for financial affairs and one for healthcare. And in both of them, you can state, I do not want this, my agent does not have the authority to act on my behalf until it has been determined XYZ, until a doctor has determined that I'm incapacitated, or I can't answer intelligently, or whatever, pick your condition. But it
Mm-hmm.
allows you to pick a condition by which the authority is triggered. And those are what we call springing powers. And there is
Okay.
debate in the legal community, as there's debate about everything, about whether we should have springing powers or whether we should just go ahead and have that authority be effective immediately, because the old instruments and durable powers of attorney required a court to make a decision to state, required a court opinion stating, yeah, this person is incapacitated. Well,
Mm.
we just saw during COVID-19 that the courts were all closed. We
Mm-hmm.
just saw doctors, nurses, everybody in the hospital being completely overwhelmed.
Yes.
So who had the time to actually stop and say, oh yeah, okay, that person, yeah, okay, they're incapacitated. So in those instances, you would want your agent to act immediately. And so we actually changed our instruments for COVID so that the agency was effective immediately.
Okay.
Um, but you can actually stipulate that. You can stipulate that in your instruments without having to have a court. It's like you can just say, my agent has the authority to make the determination that I'm incapacitated, and they can act. And then in 48 hours, have a doctor decide within 48 hours, and then it's all, you know, uh, you have covered all your bases, right?
So I'm just trying to connect the dots a little bit here. One, if someone signs a power of attorney, a durable power of attorney, or a property power of attorney, or a health power of attorney, those are the three that we're working with right now. And they're perfectly healthy. Does that give that person? I'm just gonna, name a fictitious person. So if I sign a power of attorney and I give Lisa the the authority, does she have authority to go operate on my behalf when I am just fine?
No,
No.
no, no. Authority for powers of attorney and durable powers of attorney. So, you have a durable power of attorney, and that covers everything, right? So that's kind of like your power of attorney for property and your healthcare power of attorney combined into one, but things slip through the cracks. That's why we don't use them. Then you have your power of attorney for property and your healthcare power of attorney. If Lisa is designated as your agent under either one or both,
Mm-hmm.
and even if the agency is effective immediately, it's only effective immediately if you are incapacitated.
Okay.
Okay. She cannot act unless you are incapacitated. Now, you can say that you can give her that authority. You can say, even if I'm not incapacitated, she can do whatever she wants, because 89-year-old grandmothers tend to do that when,
So wait.
give the authority like that. But
Well, so
no,
what
she
does
does
that?
not have the authority to do that.
What document does that?
That's an either.
So there is no power. Like I can't give. Like when I'm 89 or I'm 90 and I don't want to be bothered with my stuff anymore.
You
My
can
power of
designate, yeah. So if you don't want to be bothered with it anymore, you can designate, you have both a property power of attorney. There are things that both instruments have in common.
Mm-hmm.
One of those things is the determination of when the power becomes effective.
Okay, that's the difference. Okay.
Right. So the power of attorney for healthcare and for property or financial affairs, they can both be, they both should state, like, when I become incapacitated, this person can make decisions for me. Oh, wait, I'm 89 years old. I don't feel like dealing with this anymore. this person can manage my affairs now. And that's perfectly fine.
So, why are people afraid to do power of attorney then? If it can get that specific, how come people, shrink back from doing it?
Because it's it's a legal instrument.
Mm-hmm.
Um, uh, the agent is a fiduciary, and so if
Mm-hmm.
they act inappropriately, they can be brought before a court to
Mm-hmm.
account for their actions. And I think most importantly is folks tend to attribute powers of attorney to dying,
Mm-hmm.
and people don't want to deal with that. Right? I
Okay.
mean, they really don't want to deal with that. And unfortunately, we've been forced to. But I think also, kind of in a bittersweet way, the pandemic has also shown that folks recover.
Okay.
And the best way to handle, the best way to handle these issues is if you're hospitalized and you're in the hospital for 2 months or 3 months, don't you want, especially if you're a single parent or you're single or an adult, don't you want somebody acting on your behalf with your best interest? So when you come out of the hospital, everything is fine.
Absolutely. Absolutely. That's so important. I want people to stop having this fear of preparation, and it's not necessarily associated with death. Quite frankly, it could be associated with success because maybe you need someone to act on your behalf because you're like Jeff Bezos and you're going to be on the moon or wherever.
You know what? That I actually that's one of the scenarios that I use.
Okay.
What if you're going on sabbatical? You don't have to
Mm-hmm.
be Bezos. You can just be a professor who has finished with, a few years of teaching, and it's like, you know what? I'm going on a sabbatical. I'm gonna go to South Africa. I'm going to go to the Himalayas and chill with the Buddhist monks. You could,
Mm-hmm.
and I'm going to be gone for 7 months.
Mm-hmm.
But I'm not going to sell my house. I want to rent it. I want, I I have 401ks and things like that. I'm not retiring, but I want to make sure that things are being taken care of,
Mm-hmm.
right? And if something happens to me, I do want them to actually be able to find me and also to contact a loved one or a trusted agent who will tell them what needs to be done.
Mm-hmm.
So POAs are really, really important. They're not just for dying. And I really do hope people have seen that through the last 18 months and how these instruments can really benefit us.
Wow. That is amazing. That is amazing. So, if we set up our power of attorneys right, or what did you call the advanced directives? If we set up our advanced directives right, we can avoid very expensive situations such as guardianship and what's the other one?
Conservatorship.
Conservatorship.
Absolutely. Let me
Mhm.
let me let me hone in on that because I just had a conversation about that earlier today. I was like, wow, this is really prescient. Um, Guardianship is a court process.
Mhm.
It's generally like 3 months long,
Mhm.
and it's not once somebody becomes subject to guardianship, especially if they are an elderly person or a
Mhm.
disabled person, that guardianship does not end until that person dies. And
Wow.
the authority that is given in guardianship is constrained. It's constrained by the courts,
Mm-hmm.
it's constrained by the GAL, it's constrained by law. Powers of attorney versus, even if you get attorneys to prepare them, competent, comprehensive powers of attorney, it is a fraction of
Mm-hmm.
the cost of guardianship and provides greater authority and independence for all parties involved. So
Wow.
I always tell people, if you get powers of attorney, advance directives, you do not need guardianship, and you are avoiding a plethora of issues, such as grandma having to go into a nursing home, having to
Mm.
sell her home and go into a nursing
Mm-hmm. Mm-hmm.
home,
So it gets really expensive, and I'm kind of sandwich, and I'm in a sandwich spot in my life, and I talk about my three golden girls, and so with my aunt actually got really, really sick, and nothing was prepared whatsoever, and so um, I just had very limited authority to act on her behalf. And I almost got to the point where I was going to spend $6,000 only to get the interrogatories prepared. That's it. That's I hadn't even made it to court yet.
right?
It
Yeah.
was incredible.
Yeah, it is really, really unfortunate. And that's why it's very important to have these instruments prepared. I do them for college students because you just
Hmm.
never know. Your children are going away to college somewhere, and they need to be taken care of. So that's the
Yeah.
other end of the spectrum, right? But with elderly, with our seniors, and this is a generation that has significant wealth, and to not have any plans in place,
Hmm.
and then to become, incapacitated or infirm, sick, and have nosy neighbors or somebody an upset or hostile family member, maybe call the authorities, and the authorities come and they don't like what they see, and so they call the court. They call, the court, and they don't call the court, they call the police come, and then the police decide, oh, we don't like this, and so they have the senior taken to a hospital for
Hmm.
evaluation, and then all of a sudden that senior is evaluated as needing to go into a nursing home, and then a loved one doesn't even know where they are.
Hmm. Hmm.
And then from there, it's guardianship until that person dies. And
Hmm.
and even if they have a home and accounts, the court will look at it and say, well, maybe, nobody's living in the home and they need 24-hour care.
Hmm.
Then if they need 24-hour care and nobody can afford it, we're going to need to sell the home. And then this is where that cycle of impoverishment begins, when it didn't necessarily need to go
So
there.
I just want to highlight in that story you told, it wasn't the person who loved you that was making the decision. It was the state
Mhm,
that was making the decision. And so that's another really good reason to get it done beforehand,
mhm,
because when you're dealing with conservatorship and guardianship, the state gets involved.
mhm,
There's
mhm.
no ifs, ands, or buts about it. The state and the court is coming in and they're putting their 2 cents in.
Exactly, exactly. Yeah, it's uh, there. It's when I see it, Sometimes it's six in one hand, half dozen in the other, because all family members are not loving and gentle and kind, unfortunately. And sometimes, sometimes it's a good thing, but more often than not, I am seeing more often than not, like I said, folks with some form of wealth, with a home that's paid for, with bank accounts, with with retirement interests, with pensions being placed in the system, and then all of their resources are being sucked by nursing homes to pay these nursing homes. For example, in Illinois, monthly nursing home is $8,500 a month. Who can afford that? In New York, it's like 11,000. Who can afford, right? And so they go to sell the home to pay for this care, and they're in the nursing home. And then at that point, once all of those assets have been used up, it's time for Medicaid, right? And so then the wealth, the fruits of that senior's labor have all just been used up, and used up by the state, used up by nursing homes, by lawyers, by judges.
And so they ultimately, your wealth gets eaten up by bureaucracy, essentially. That's what happens.
Hmm. Hmm.
Wow.
Yeah,
Wow.
exactly. It's so, I mean, that's why I tell people, folks come to me for estate planning, and so they want to talk about the wills and they want to talk about the trust, and I'm like, yeah, well, first of all, we need to talk about advanced directives, powers of attorney, and so forth. And what I call them, like I said, we call them advanced directives, and we've only really been talking about powers of attorney, but there are a couple of other instruments that I think are really important that folks don't really know about. And those are HIPAA forms. And
Oh,
HIPAA forms are the instruments by which you designate who can receive your medical information.
okay.
And generally, you don't really hear or see about these forms until there's an emergency,
Mm-hmm.
and you or a loved one is sitting in the ICU, and then, or you're at the window and they're like, okay, here, sign here, sign here, sign here. And part of what you're actually signing are forms that state who can receive your healthcare information. And so they'll ask you for one person, maybe it's the person who came in with you, but maybe that's not the person. Maybe that person is just there because, your son was in another state, or something, was traveling or something, right?
Okay.
But no one can receive your healthcare information, no one should, unless they are designated on a HIPAA form.
Okay.
And that's really important too, because our health information is private, right? And you may have some things, that you don't want loved ones, you don't want your daughter, you don't want, your grandmother or mother to know about.
So the
Or you may
POA
want
doesn't
everybody,
necessarily.
to know about it so that they can confer with each other,
Okay.
right? And then one person be the decision maker, that's the agent under the healthcare power of attorney. But you may want like 4 or 5 people on those forms so they can all talk.
So the POA doesn't necessarily give the person access to your HIPAA information?
Oh no, the agent under a healthcare power of attorney most assuredly does.
Oh, okay.
But let's consider this scenario. What if your agent under a healthcare power of attorney is traveling for business,
Okay.
and you get into an accident, and you have a medical history that needs to be considered
Mm-hmm.
for your care, and your sister or mother or cousin, another family member, is with you at the hospital.
Mm-hmm.
and they asked the doctor about how your previous condition might affect the care that you're receiving because of this accident you got in. Well, if you're
Mm-hmm.
not on the HIPAA form, that doctor can't say anything.
Yeah.
And so when your son comes the next day, either all care is stopped until he gets there,
Mm-hmm.
or the doctor is making decisions without telling the other family members what the implications are.
I see. I see. Wow. There is so much for us to know and so much for us to, um, focus on. But I really thank you for unpacking it. I'm so excited for the next show, guys. She's coming back on August 19th. Okay.
Okay.
So send in your questions, but this time we're going to talk about living trust. We're going to talk about last will and testaments, um, and we're going to talk about what's that something gift writers.
Oh,
What
the
is that?
statutory gift writer. Yeah,
Statutory gift writers. What is,
yeah, that actually goes along with a New York POA. So yeah, we'll take a look at that though. Mhm.
So we'll take a look at those things. Send in your questions in case you have something specific. But Max has been so gracious to spend this time with us to make sure we're doing the right things in our lives to protect our future and the generations behind us. Is there any last words you want to leave the audience with?
No, just plan ahead, right? I mean, I've always been a planner. I love planning. But it's really important if you want to preserve your wealth, if you want to preserve your peace of mind, your family harmony, whoever your
Mm-hmm.
family is, your chosen family or your birth family, um, it's important to just plan ahead and get those instruments done and not the do it yourselfer kind, because they kind of have gaps. If you just consult with legal professionals, and you don't necessarily have to obtain one, but definitely consult with them, because I can tell you the instruments that you need are definitely more than what you can buy for 10.99.
So no legal Zoom. Oh gosh, our fortune is worth more than legal Zoom.
Absolutely, absolutely. If you think about it, let's just say you've got a house, $100,000. Let's say you've got life insurance, $100,000, $200,000, and that's just for right now, right? And you may be in your wealth accumulation phase. What's
Mm-hmm.
what's 1% of that? Doesn't 1% of that? Everybody's talking about
Yeah.
the 1% people. Let's talk about the 1% of your wealth. Isn't it worth 1% of your wealth to save the other 99%? I think so.
I love it. That's a great way to put it. I have to update my last will and testament and my healthcare power of attorney and all those things after talking with you. But I will say this: immediately after I got it done, I felt such, I don't know. I felt at rest because
Mm-hmm.
I knew that my hard work wasn't going to just go to waste.
Mm-hmm.
You know,
Mm-hmm.
I don't I do not want the state to get my home or my money or my wealth or anything that of that nature. And I don't want things going into probate court. No way.
Right.
All right. Well, thank you, Max. And bye bye, family. You guys have a great night.
Thank you.